The clock strikes 12, and it's now time for Late Night Legal Consult, where the advice is free, but you can't call us your lawyer until your check clears. Late Night Legal charges for all services commensurate with what the market can bear in a competitive fashion. If you do need free legal advice, please reach out to your local pro bono society. Tonight, on our late night podcast consultation, we will be tackling the difficult yet absolutely necessary requirement to have a validly executed will when your loved ones pass away. If you yourself or a loved one do not have a will prepared already, please reach out to Late Night Legal, as we have an efficient as well as competitive product that we can provide you for all of your estate planning needs, including non-probate dispositions of property, which we will talk about later, as well as drafting proper and necessary documents such as wills, powers of attorney, trusts, other guardianship papers that might be necessary. Any of this documentation can be provided by a competent attorney, so long as they have a long history of doing efficient work. Here at Late Night Legal, we pride ourselves in working while the competition sleeps. Death is a destination we all share together. When facing this existential problem, we should be comfortable discussing how we want our estates, essentially the things we own, to be disposed of after we pass away. Now, I think back to the time that I was in law school, and I remember reading an article where Snoop Dogg, that's Snoop D-O-G-G for the unacquainted, is actually discussing with a newspaper about how he doesn't have a will. He has an estate valued at over $300 million, but no will. Well, what does that mean? When you die without a will, there's essentially only one thing that can happen. It will be disposed of under what is known as intestacy. All that means is you don't have a will. Intestacy has a limited application in jurisdictions that follow civil law, or formerly Roman law. The doctrine of forced heirship automatically gave a deceased person's next of kin title to a greater large part, the forced estate, of the estate's property. Now, this Roman law can be very harsh. If you do not have a validly executed will, the statute will be applied to the facts of your case, no ifs, ands, or buts. Now, Snoop Dogg might not be concerned because he says, well, I'll be dead, so why should I worry about it? The real reason you should have a will is for ease of mind for your friends, family, and loved one, anyone who's going to be dealing with your estate. Yes, you can appoint a guardian for your child. Yes, you can appoint a trustee for your child. Yes, you can try to avoid taxes, you can save money, you can make a smooth transition of a business, but honestly, it's really peace of mind for the people you're leaving behind. That will be the most effective part of having a will, because there is one person who absolutely will not guess when it comes to who gets what, and that'll be your local county commissioner or judge that is probating the estate. If the statute says one person gets all of the money, that person gets all of the money. No exceptions, no appeals. You can litigate it for years, but if the statute says that your long-lost relative gets the money, then guess what? They get the money. Now, this is not just an abstract thought. Tonight's consultation, I want to bring up a case that I worked on where I won't name any individuals, but the case is absolutely real. It's a case that I worked on as a young associate, and it should be a cautionary tale not only for those in my home state of Washington, but all around the United States as to why you need a will. The short facts of the case are: The decedent, the person who passed away, had recently inherited all of his wife's estate. Essentially, his wife passed away, and in the state of Washington, most of that estate, by operation of law, because we are known as a community property state, pretty much all of that vested directly to him. She also did not have a will. So, within less than a year, he passes away. Now, he had been married for over 3 decades and had 4 stepchildren. These are the children of his now deceased wife, who were still living, and they were set to inherit everything. However, some company out of the state of Utah, was able to track down this individual's living mother. She was living in a institution, most likely in the state of Arizona. She was 94 years old and had in fact abandoned the child as just a toddler, maybe 3 or 4. She said she couldn't take care of him, left him on the doorsteps, and disappeared forever. And from all the available information, the person who passed away, the decedent, without a will, essentially left everything to his mother, whom he had no contact with, whom he didn't know was alive, and most likely would be rolling over in his grave had he known that his mother, who abandoned him, never gave him a single thing in his entire life, was set to inherit several $100,000 out of his will, or out of his estate without a will. This is the cautionary tale. You need a validly executed document for ease of mind for those that you leave behind. Even if you have a very small estate, just several $1,000s, you should take the appropriate steps to consult with an attorney to ensure that those small assets can get into the hands of your loved ones very quickly. Sometimes that can be done still by going to court, but there's still fees involved. It's usually several $100s to file a case. So if you have, say, a bank account, you can make that actually not subject to probate. Now, what does that mean? Probate just means that the court is going to be overseeing the administration of the estate. Non-probate assets, like I have in my bank account, you can actually name a beneficiary. These are known as transfer on death, TOD, and these will actually transfer. They're what are known as ambulatory accounts, which means as soon as you pass away and you can provide a death certificate, the person who's named either in, say, a deed for a home or a bank account beneficiary, those people will have a legal claim to that right away. This could severely ease the administration of a estate and decrease the chances for litigation of the estate because they are not subject to the court's jurisdiction. Essentially, it will automatically go to the individuals named. This can be an excellent tool that can be utilized to simplify the estate. Some estates are more complicated than others and might need the appropriate trust formed, as well as other mechanisms that can be taken to help mitigate what is usually looked to as the estate tax. Now, most estates essentially aren't subject to a direct tax anymore, but that doesn't mean that certain forms of income, as far as other assets which will directly lead to disposable income coming into your possession, might have an associated tax. So you should consult on a case-by-case basis with your attorney to determine how you can minimize your tax implications. Circling back to my main point, the real reason that you should have a will is for ease of mind. You should also have a valid power of attorney so someone can make difficult legal decisions in case you are ever incapacitated or otherwise deemed unfit to make your own legal decisions. All of these documents can be done in advance. They usually will require witnesses who will be nonpartisan, that is, they won't be subject to the will or beneficiaries. And they should typically be notarized, so make sure that you have a notary on hand in order to execute these documents. These documents will be key in you having a quick and uneventful administration of an estate. Some estates can take months, years, and in very rare occasions, such as estates that have large timber assets, can even take decades. All of this heartache could be mitigated very early on with a competent legal advisor in your corner. So to that I say, please don't procrastinate. Don't think you'll do it tomorrow. Do all your loved ones, friends, family members, anyone set to inherit or possibly administer your estate, do them all a favor. Reach out to your local attorney. If you're in the state of Washington, I can help provide you with legal representation in pretty much all of Western Washington. Reach out to Lateknightlegal or any other competent attorney in order to properly administrate your estate.